All right, we're hitting the pause button while they go to that video so we can bring in our guest for this hour to discuss. Joining us from Denver, Colorado, criminal defense attorney Jeffrey Wolf is with us. Jeffrey, we've got a new witness on the stand for the defense, and we know that she's likely going to get to the topic of Karen Read and John O'Keefe lovey-dovey there inside of the bar, and perhaps that Karen Read really wasn't drinking that much, that she wasn't under the influence. Do you think this is proper use of the defense case to spend time with a witness like this when we know Jennifer McCabe plus the surveillance videos have shown that there was no outright fight between the two at the bars?
Yeah, I think you want to establish that there wasn't a real motive for Karen Read to have killed him. And so you want to show that the relationship was not as bad as the state is presenting it to be. Because couples fight, right? Because there's a lot of evidence that has been presented to show that they were fighting and they were arguing and that Karen was mad at him at different points during the relationship and in the hours and days leading up to what happened here. And so what you want to show is that there were other times where they were getting along just fine. And so to show that right before this incident that they were in a very good spot and that they were getting along and that there was affection between the two of them, I think is more than appropriate, because it allows the jury to see that this relationship wasn't all dark, that there was affection, and that the two of them did also get along.
The Commonwealth called Karina Kalakithis the first time around. They did not call her this time around. You have the defense bringing her in. Do you think that this may also mean that Higgins, Alberts, they could be brought in by the defense, even though the Commonwealth has gone out of its way to not allow this jury to get the full picture of that evening and the people at 34 Fairview? Or is it going to be too risky for them, the defense, to bring in especially Higgins and the Alberts?
Yeah, I think retrials are so interesting, Ted, because what you have is everybody has now had a chance to see how witnesses present and how witnesses do on the stand and what information they bring forward. And then each side gets to decide, do they want to take the second bite at that witness's apple or not? And so now we're seeing the strategy from the state having already played out of that witness wasn't helpful or that witness was a waste of time. And so we're going to move past them. And now we're going to see what the defense is going to do. Are they going to decide we're going to bring that person back in? Or like you said, is there too much risk in putting that person on the stand without the benefit of the control of cross-examination, and now having to use direct where we have less control of this person and allowing them to speak in more open-ended answers? And so I think there may be some risk in some of those other witnesses, whereas this friendly witness, let's put her on.
That's a good point. And it does feel like, though, that they are beginning to retell the story of that night with the defense perspective at the front this time around. Starting with
Karen and John got along, at least that
the
night.
Waterfall Bar. We're going to get to our break. We'll get you back in for more of that testimony with that surveillance video. Plus, our Matt Johnson is there on the ground. He's been speaking to people outside of this courthouse. We'll have a live report from him next. All right, let's bring back in criminal defense attorney Jeffrey Wolf. Jeffrey, is this surveillance video moving the needle for you at all for the defense?
Well, what it's doing is it's laying out the story of the night for the jury in a way that the prosecution didn't do, right? The prosecution avoided a lot of setting up the scene, setting up the players for the jury. And this witness, who is incredibly friendly to the defense, is doing just that. They're trying to show the separation between the two groups. They're trying to show that John O'Keefe is with Karen Read. They're getting along, and then this other group has the conflict. This other group is separated from them, and they're just trying to lay out for the jury exactly what is going on in this bar just before all of this incident, that whatever happened at that house just before it happened, look at what's going on at this bar and how these two groups of people are behaving and how well John O'Keefe and Karen Read are getting along just before everything happens.
A lot of Brian Higgins, Brian Albert talk. If I'm a juror, I want to see him. And you go back to the opening statements, they said these guys got rid of their phones when the day before they were supposed to turn them in. Albert slept through the chaos in the front yard. If they want to go back at it in closing, they're going to have to either bring them in or get those facts into evidence. And the easiest way, obviously, is to roll the dice and bring both of those guys in the defense case.
or show the lack of evidence. Remember, the jury is going to be told that they can consider the lack of evidence when they're back there deliberating reasonable doubt. And so when you talk about what the prosecution didn't present to them, who they didn't bring in, you can tell the jury, why didn't the prosecution put them on the stand if there's nothing to hide? Why didn't they bring them in their case to tell you what they did and why they didn't play a role in the murder of John O'Keefe? Why did they hide them from you? Why didn't they put them on the stand? The mere absence of those people is something that they can present to the jury as well if they are worried that putting them on the stand under direct will cause a problem for the defense case as well.
I think that's a great explanation for why they may not call, and it seems like they're not calling Michael Proctor, because to be able to say, why didn't the prosecution bring him in, it's powerful.
But they were able to get Proctor's texts in, you know, they got more Proctor in than they have in terms of Higgins and Albert, and I think it's compelling that why did they get rid of their cell phones? Why? And the day before they were supposed to turn them in.
Certainly. We'll see how it comes out. Jeffrey, stand by. We have to get to a break. We're going to get you in for more of that testimony. But first, Lori Vallow Daybell showed up in court today. We weren't sure because she called in sick yesterday. Is she there, and what does she look like there inside of the courtroom? We'll be able to show it to you. That 30-minute delay
there,
is up.
Barely. Which we can't show. Jeffrey Wolf, what's your take on it? It is because she's acting as her own attorney and she's claiming she's sick. She looks sick. She sounded sick the other day on Monday. What's your take on what the judge should do here? Is it a problem? He seems to he wants to move ahead because he's got this jury panel waiting.
I suspect he isn't totally certain that she's sick, but I once hacked my way through a trial and pointed out to a jury that my cup wasn't full of water, it was full of Theraflu throughout a trial. So trials go forward all the time when people are sick. I think that COVID kind of gave us a misunderstanding of what happens in the court system when people are ill, because we didn't want to spread COVID, so we canceled a lot of things when people got sick, and we didn't let people come to court when they were sick. But courthouses are a lot like other workplaces where people push forward when they are ill, because there is a lot of moving pieces when there is a trial set. You can't just reschedule something because somebody is ill unless they are so ill that they cannot proceed. She appears able to proceed if she is able to talk, if she is able to sustain a full day, she is able to move forward. I know that I was extremely ill through the trial that I did, but I was able to get through it. I was able to form coherent thought, and so I was able to move forward as a adequate representative for my client.
Did you win?
Through that trial, the judge knew it. I didn't win, but the facts were quite against me, but the case had to go forward for a variety of reasons that I can't get into, but it is what it is.
Gotcha.
But cases move forward when people are sick.
Do you think that it's an issue on appeal that she could use if she put herself in this situation, but the judge saying there's not any medical information? I'm guessing the medics there at the jail didn't give her a get out of jail card or stay in jail card is what this would be if she was able to show some kind of real diagnosis.
My assumption is that the judge has done the right thing and has had her evaluated by the medical staff at the jail to determine whether she is medically fit to proceed forward, and that is why he is pushing forward with this trial. If he's done nothing and has just moved forward, then yes, she may have grounds to say that she is not able to be adequate counsel for herself. But I would be shocked if that was what the judge was doing, although his lack of patience for her has been very clear. But I would be surprised if he does not have a clean bill of at least adequate health for her to move forward.
I know he did write an order for her to be evaluated within the next 24 hours, and that was on Monday after she made that appearance. So that's been documented. To Jeffrey's point, so he knows what he's doing.
Oh yeah, his patience is wearing thin, but you can see that overall this is a very patient judge with a very unusual witness in terms of Lori Vallow Daybell. Jeffrey Wolf, thank you for your analysis. We are going to get to a break. When we come back, the rest of that testimony in the Massachusetts courtroom for Karen Read, the murder retrial. We've got a former friend of Karen Read's on the stand showing video. Stay with us. You're watching Court TV.